OCO yate Farina King Yinishye Bilagana Nishle Doki Ani Bashishchin Bilagana Dashiche Dosinijini Dashanale Akut Egot Sak Nishle. Hello, my name is Dr. Farina King, and I am of English American descent on my mother's side, Bilagana, and born for the Towering House Clan and Blackstreet Woods people, Kia'ani and Sinijini on my father's side, a citizen of the Navajo Nation. And it's my honor and privilege today to actually introduce my Shade, as we say in Navajo, my older sister, Heather Tanana, Professor Heather Tanana, and welcome you all to this session of the 48th Annual Symposium on the American Indian at Northeastern State University here in Tahlequah, Oklahoma. And this session is titled NEPA, N-E-P-A, What is it, and why should I care? With Heather Tanana, who is a JD, MPH, Dene, also, my kin and a part of my clans, SQ Quinney College of Law, University of Utah. As you probably know, this session is one of many that are included in this year's virtual agenda. So it is our first time all 100% online. So please spread the word. This is really such a special lineup of great speakers like Heather Tanana today. And please do take time to visit our website at nsuok.edu/symposium for more details regarding the agenda. All sessions will be recorded and made available in the coming weeks. So thank you for consenting to that and allowing for that. These are such important conversations, so we're grateful to be able to share them in these avenues and venues. Heather Tanana is a research associate and Stigner Center Fellow at SQ Quinney College of Law at the University of Utah, based in Salt Lake City. Ms. Tanana is also associate faculty at the Johns Hopkins Center for American Indian Health, where she works with the center's training team on developing and teaching institute courses and collaborates on health policy related work. Ms. Tanana is experienced in state, federal, and tribal courts and clerked at the U.S. District Court for the District of Utah. She also founded the Indian Law Section of the Utah State Bar Association. Heather, I'll just call her rather than Ms. Tanana. Her research interests include exploring the overlay between environmental and health policy, promoting better practices in Indian child welfare, and criminal justice in Indian country. She is a board member of the Urban Indian Center in Salt Lake City. She is a graduate of the S.J. Quinney College of Law and holds an MPH from Johns Hopkins University. So without further ado, we'll turn the time over to Heather. Thank you, Heather, for joining us today.
All right. Well, thank you, Farina, for that welcome and introduction. As mentioned, Heather Tanana Yunishe, and Farina went through our plan. Shema Bilagana. So I'm really happy to be here and kick this off. And since we have a nice smaller group here, I really encourage you to use the chat function or questions so we can kind of engage in some dialogue with a smaller group here, particularly hearing about what your interests are. As Farina ran through, I really have a strong personal drive and professional interest in looking at really all things that affect our Native communities. And in particular, I love exploring the overlap between environmental law, environmental hazards, public health, and it's a pretty broad area, as you'll see in our presentation. Let's see here. So to get us going, the title of my talk today is NEPA, what is it and why should I care? And the National Environmental Policy Act, it's really one of the laws that should be everyone's favorite if you care about the environment, because it allows anyone and everyone to engage and participate in the process. So, starting off, before we really dive into the law and what it is, I want to talk a little bit about the background, the underlying challenges that we face in our environment, right? And that's really at the heart of the environmental justice kind of movement and initiative that I'm sure many of us are familiar with. And the environmental justice movement, it was originally started, really by individuals, primarily people of color, who wanted to address the inequity of environmental protections in their communities. And it came off of kind of the civil rights movement in the 60s, when community members started to sound the alarm about public health dangers for their families, their broader neighborhood, community, and themselves. And what's up on the slide here is the definition of environmental justice. We don't really have one kind of widely used. The EPA's, Environmental Protection Agencies, has set forth this definition that a lot of people rely on. And, it says environmental justice is the fair treatment and meaningful involvement of all people, regardless of race, color, national origin, or income, with respect to the development, implementation, and enforcement of environmental laws, regulations, and policies. And then EPA goes a step further and says, these goals, environmental justice, will be achieved when everyone enjoys same degree of protection from the environmental and health hazards and equal access to the decision-making process. So you really see kind of these two components in environmental justice, right? One is kind of the exposure that our community can experience from environmental harms or hazards to both environmental and the human health. But then also that second component that talks about the ability of an individual, the community, to actually engage, to have a seat at the table when decisions are being made that impact them directly. So, as you read through this definition, I want you to think about that for your community. Does everyone in your town have the same degree of protection, that same access to be a part of the table, to be a part of the discussions when they're considering, putting a new kind of expanded development, whether it's new housing or some type of business power plant development? Does everybody have a voice in that discussion? And depending on your answer, if you say, well, yes, you're very fortunate, is that still true if you expand that geographic boundary? So you go beyond your neighborhood to the broader town boundaries, or beyond the town to the county, to the state level. You're on the reservation boundaries, right? So this environmental justice concept, the movement, right? It really pulls out and highlights some of the key issues that NEPA actually was intended to deal with. And when we look at environmental justice in Indian country specifically, I'll just note, a little thing on terminology, right? In the law, the terms that we use are Indian when we talk about tribes or native indigenous people. When we talk about the land base, we use Indian country. That's the term that's in our statutes. And so by default, I tend to use that language being lawyer trained. But going back to this slide, when we look at environmental justice in Indian country, certainly we have that first prong, right? Native Americans are being exposed to hazards and to risks at higher rates than the general population, right? And in part, this ties in a lot with our federal energy policy that was implemented over several years by the government, right? That the federal government wanted to encourage modernized tribes. So they pushed kind of these more classic fossil fuel development of oil and gas, right? And uranium mining, different things like that. And Navajo Nation alone has about 1,000 old mine and waste piles. But after these mines, many of which are closed, they've received only about 1% of the actual cost to be able to clean them up from the federal government. So a lot of times the development of and push for energy in Indian country it occurred in or near tribal communities, but left them with few of the benefits and most of the harms, right? A lot of that kind of fossil fuel development on Navajo Nation, that energy they were producing, it went off reservation. Only about 20% of it remained to electrify Navajo Nation, whereas 80% went out to other towns off the reservation. Again, a lot of examples you can look at, but Tar Creek Superfund site, right? 80% of the contaminated lands were Indian owned, seeing elevated blood levels with showing that level of contamination that passed into the children and has negative health outcomes. So again, if we look at that first kind of prong of under the environmental justice kind of framework, yes, there is disproportionate exposure occurring to Indigenous communities. But there's also something really unique, right, about tribes in the United States, about Native Americans, Alaska Natives. And it raises issues when we talk about environmental health, environmental justice that go beyond just trying to get equality among different communities, right? We have to consider our history of colonialism in this country. We have to consider the unique views that Indigenous communities have, right? So these additional exposures, given the way of life, are kind of balanced with harmony, it actually can contribute to additional exposure points because of the dietary practice and the cultural and traditions that are practiced in each community. And we have to also consider, right, the tribal sovereignty exists. That isn't the same for other groups of color in the United States. That tribes have a really unique government to government relationship with the state, with the federal government, and that they have certain treaty rights that they can call upon. And then that, that picture kind of there kind of brings those two together, that historically, our environmental health models, when we looked at routes of exposure, they were much more limited. And it's been in the last 5 to maybe 10 years that it's really expanded, and we've started to develop these Native American exposure models that recognize the greater connection with the earth, with the environment, and will recognize these other pathways that can happen, to other exposure pathways that can occur through tradition, through cultural exercises, and things like that. So kind of the takeaway, I think, really here is, yes, environmental justice is important in Indian country, but it's going to look a little different than it might in other communities. And the way that we view environmental health, the way we view exposure pathways, those are starting to be, to develop more, to consider mental health impacts, right, of environmental exposures and other things like that. But we still have a little ways to go. So again, actions can have a significant impact on the environment and our health. Americans experience disproportionate burden. And I think our fights against the pipelines are a really good example of environmental justice and community action. So I suspect everyone has heard or is at least a little familiar with the Dakota Access Pipeline dispute. There's also, a few other pipeline fights that have gone on in protest. But with the Dakota Access, right, this was a huge multi-billion-dollar project that was proposed to carry a pipeline across the Missouri River, just north of the Standing Rock Sioux Reservation that straddles the North Dakota and South Dakota border. The Standing Rock Sioux and Cheyenne River Sioux tribes essentially, raised their concerns that this pipeline would contaminate the water source that they rely upon. And again, it was a concern, right? Not just that the contaminations from the pipeline, right? There might be a leak or other things that it would get into drinking water that way, but also that the contamination would impact their ability to use water in their cultural and traditional practices. So again, sure all of us are familiar with this, right? But many tribes view water, it's sacred, it's integral and part of very important traditions and cultural practices. And so under the Obama administration, the U.S. Army Corps of Engineers was preparing to do a full environmental review. And then we had our change in our administration. And in February of 2017, Trump took office as president. And under his new administration, the agency switched course and decided to not undergo an environmental review and instead just grant the permits that were needed. So lawsuits followed. And in June 2020, so this would have been just last summer, you may have seen headlines and news reports about how the tribes secured victory. All of the protests were not, and they won because the pipeline was shut down. Now, the attorneys in our group really knew that the fight was far from over, because what had happened in June of 2020 is that the judge of the case, he ordered that a full environmental review is necessary. Okay. And as we'll see as I get through the law, that doesn't necessarily mandate a certain outcome. This means that the agency, the federal agency, they did not go through the process that they were supposed to in granting that permit. So if you're interested in it, you can kind of find out more details of the real specifics of why the case was reversed. One of the considerations that the agency was required to go back and do was to specifically look at the tribal treaty rights, how an oil spill might impact their fishing or hunting rights. There was also some discussion about an environmental justice analysis. Would Standing Rock be disproportionately harmed by a spill? Things like that. But, what I want you to know is, these pipeline fights, these actions that are going on outside nearby our communities, a lot of time at the heart, they're a NEPA dispute. So that's why it's really important. I think if you care about what's happening in your community, if you want to say, or at least to have your voice heard, you should be familiar with what NEPA is. So the National Environmental Policy Act, right? It's not the National Environmental Protection Act. And that's an important distinction to make. There's, again, a lot of trainings that we do at the Stegner Center, other nonprofit organizations do. So I'm going to run through really a brief introduction to NEPA. After this, if you're interested in learning more, I can certainly put you in touch with those resources. But way back, NEPA, right? If we jump ahead, it was passed by Congress at the end of 1969 and signed into law by President Nixon at the beginning of 1970. But what led up to its passage? Again, right off the civil rights movement, about the same time, we're getting a lot of environmentalists writing about the environment, bringing attention to these issues. And in the year that NEPA was passed in 1969, we also had a series of large environmental catastrophes that occurred. So the first one, kicking off the year in 69, was the Santa Barbara oil spill, right? There was a blowout of a drilling rig that was 6 miles offshore. 200,000 gallons of crude oil bubbled to the surface, spread over 800 square miles. The incoming tides brought thick tar to the beaches and marred, over 35 miles of the coastline there. And in June, there was an oil slick and debris in the river that caught fire in Cleveland, Ohio. Crazy thing is that was the 10th time that the river had caught on fire. And the Project Releason, that involved an underground detonation of a 40 kiloton nuclear bomb, where they detonated in the hopes of increasing natural gas production. The detonation was near Battlement Mesa in Colorado. A lot of subsequent litigation following that about claims that the detonation contaminated the very gas supplies that they were trying to expand. So again, just all of these events were in getting national attention, combined with the rise of kind of an environmental movement, the environmental justice movement that really led to the enactment of NEPA. So there's 3 main goals that NEPA is intended to do. One, it's to achieve an informed and engaged public, also seeks thoughtful and informed agency decisions, and resulting in an increased environmental responsibility. And you can see on the right there, these different components of the NEPA process that really fall into those 3 main categories. Has the agency identified the purpose and need of that project? Are they being transparent, looking at the impacts of that action, of whatever it may be? Did they give an opportunity for the public to participate and to comment on also any aspect of the project, right? The public can comment on the project purpose that isn't really needed. They can comment on the environmental impact that might result, ways to mitigate negative outcomes, right? There's also supposed to be interagency coordination, that agencies are talking to one another so that they're making informed, thoughtful decisions and evaluating all of the possible alternatives and scenarios that they could take. And like many acts, Congress often, when they pass a law, will set forth the purpose of the law. And for NEPA, this is what Congress said was the purpose, right? It was to declare a national policy, encourage productive and enjoyable harmony between man and his environment, promote efforts to prevent or eliminate damage to the environment and biosphere, and stimulate the health and welfare of man, enrich the understanding of ecological systems and natural resources important to the nation. So a lot of goals in there, right? You see kind of this trying to get this balance between man and his environment, protecting the environment, protecting human health, right? A lot of good general goals in there. As we go on, bit of a spoiler, right? They're really aspirational in nature. Congress also set forth the policy, a national environmental policy, and continuing federal responsibilities, right? This declaration, again, kind of has some competing values in it as well, right? Recognizes that we are trustees of the environment for succeeding generations. We want to assure a healthy, productive, cultural, pleasing surrounding, right? There's a lot of different benefits we can get from our environment. We want to attain the widest range of those while still not having severe permanent consequences, right? Preserving important historic, cultural, and natural aspects, achieving balance between population and resource use. So again, most of these are positive things. Protecting environment, protecting cultural values. but you do see that there are competing demands, that it is not all about environmental protection at the expense of all other values. And it's also still kind of soft language, right? No clear mandates or really enforceable legal things at this point. So that gets us over here to really what is the heart of NEPA. This is the statutory mandate here. And it's that for every recommendation or report on a proposal for legislation, and I'll come back to that, but this is really the big one. For any major federal actions that significantly affect the quality of the human environment, a detailed statement has to be prepared on the environmental impact of that proposed action. Okay. So that leads us to, well, Heather, what is a major federal action? All right. So at the offset, the NEPA is a federal law, right? So it's generally not going to apply to non-federal actions. So things like a private actor or state government, unless it relies on a federal permit to do something. So sometimes, even though the action may be taking place on state or private lands, if a federal permit is required, then it might trigger the NEPA requirement. All right. Major is going to refer to kind of the significance of the action, the significance of the impact. So let's say there's a large, a road, right? But that road is already there and we're just going to repave it. This could be a long stretch of a highway, could be a pretty long project that's proposed, but the impact is going to be minimal if that road is already there. It's already been paved once. We're just kind of doing a new repavement on top, right? That might not be considered major. Again, federal action has to be something that the federal agency has authority over. Again, like permit, it's on federal lands or is funded significantly by federal monies. If the agency doesn't have that authority, they lack the discretionary authority to deny or modify it, right? Something we'd call a ministerial decision. NEPA is not going to be triggered. So just make sure I cover it all. Something that's, I don't know how many people are familiar with, right? We tend to think of Indian Health Service as purely being involved in just kind of the direct healthcare delivery for Native Americans in the US, but they also have a sanitation facility construction program, right? And that program is focused on bringing in drinking water and sanitation lines, right, like sewer disposal into homes across the United States on reservations. And when they go to bring in these lines, right, build some infrastructure to bring in water access, right, they have to comply with NEPA. The DAPL case was not, again, right, not directly on tribal lands, but that federal permit was required for it to grant an easement, right? So this initial hurdle of is a major federal action involved, right? You'll have to kind of look at who are the players, where is it taking place, how is it funding? But all of that's going to be done by the federal government. Okay, whether it's significant, again, kind of where it's taking place, how intense it is, right? Those are going to help us determine whether the impacts are significant and therefore would be subject to NEPA. Okay. How do we know if the action affects the quality of the human environment? Right? NEPA uses a very broad definition of human environment. It's our natural physical environment, relationship of people with their environment. And that's really important, right? Particularly with our tribal communities, because remember our Native American kind of exposure model that we use in environmental health, right? A much more holistic, comprehensive model that we consider, and what that relationship means between the community and their environment, what it looks like. So very broad. All right, so we know we have a major federal action, right, that's being proposed. Permit has to be granted for something. All right, and the federal agency that's overseeing that project is trying to decide what I have to do under NEPA. And there are 3 paths to NEPA decision making. First are the categorical exclusion. And you'll see there in parentheses, 95% of projects fall under a categorical exclusion. So the vast majority of NEPA decision making is falling under that category. Only 5% go on to be environmental assessments. And then a mere 1% are the full-on environmental impact statements. And these 3 different categories that we're moving on to the next, going down that line when the anticipated impacts are more significant. And it also, as we move down that line, we'll see that as the impacts, the significance of the impacts increase, it's also going to result in a more burdensome process. It's going to be a more thorough analysis and review that's required as well. And just as a recap, right, if the major federal action does not significantly affect the quality of the human environment, right, that's going to also affect where we get through here. So let's go through these 3 real quick. Categorical exclusion. So you'll also hear some people may say CEs, they may say Cat X's. They're called different things, but at its core, a categorical exclusion is a category of actions that normally do not have a significant effect on the human environment. Right? Again, NEPA, we want to protect the human environment, and so if it's not going to have a significant action, then the thought is, well, it doesn't really need to go through the whole process. I'll throw out there briefly, again, this kind of just depends on how familiar any of you are with the background, but there is the Council on Environmental Quality. They are responsible for putting out regulations, which is how you implement a statute. And so there's a kind of a fight going on right now under the Trump administration. The CEQ put out new regulations. They're in litigation right now. So it's a little unclear how those are going to pan out. These sites right here, 1508, are to the new regs, but categorical exclusions didn't really change too much. They're still available and will still be available. We have ones that are implemented by the agency as well as by Congress. If it's by the agency, they develop their own list and criteria, goes through rulemaking. The difference happened really on that right part between the new rules and the old rules. Under the old rules, categorical exclusions generally weren't available because of extraordinary circumstances, an action that normally we would have excluded because it doesn't normally have significant environmental effect. Now we're not going to exclude it because, again, extraordinary circumstances have occurred, so that action may have a significant environmental effect. The last sentence is what changed in the new regs. An agency may still go ahead and exclude a proposed action if there's circumstances that will lessen that impact. So just kind of something to kind of keep in the back of your mind. But, categorical exclusion, like an example would be painting an old outhouse, right? It's already there. and established, we're just going to paint it, right? I certainly can't really think off the top of my head any big concerns I would have about painting a standing structure that was already there that might have on the environment or a human, right? So that's what categorical exclusions are intended. And again, the vast majority of major federal actions are by categorical exclusions. So they don't go through any further analysis. Now, the second step, environmental assessments. Okay, this is where the agency usually will go through an EA first if they're not quite sure there's going to be a significant impact, right? So we're going to put together an analysis to determine whether the action is likely to have significant effects. If they are, you go through your EA and the agency determines, oh yeah, this proposed action is likely to have significant effects, then they have to go on to the next step and do a much more comprehensive environmental analysis, which is that EIS. If the agency determines that there are no significant effects, then they issue that finding of no significant impact, here referred to as a FONSI. So in some circumstances, the agency, if there's, going to be a significant impact, but it's fairly narrow, they can try to offset that by proposing mitigation. And so that's just another kind of thing you might hear or read, that the agency or applicant proposes to mitigate a harm so that the impacts would no longer be significant. Okay, so our final category here are our environmental impact statements. This is what the Army Corps of Engineers was ordered to do with the DAPL situation. You don't have to do an EA first, right? Sometimes the agency, they might think, oh, this is a big project. It's going to have some impact. We're going to just jump right over to an EIS rather than going through an environmental assessment. And it will issue the EISs first in draft format and then in final. And that's important, right, for our public participation process. Now, a lot of people think that the EISs are more defensible, right, from a legal standpoint, that the agency went through a thorough analysis. There was no requirement that they had to show the impacts remain below a certain level of significance, just adequately considered. But my colleague and I have done some research on the litigation of NEPA documents. And what's interesting is that some of our data shows that EISs are actually ruled inadequate at higher rates than the EAs. So just something that's a little interesting there. This summary table is kind of a nice recap here, right? So we start out with our proposed action. The agency is going to coordinate, reach out to other agencies if they're involved as well to do their analysis. They'll check, hey, is this fall within the scope of an agency or legislative CE? If yes, are there extraordinary circumstances? Nope. Okay, our categorical exclusion can apply, and boop, we're done. If it doesn't fall within that scope of an agency or legislative CE, right, then they're going to be looking at whether there's a significant impact on the human environment. They can go to the intermediary step first on an environmental assessment if they think it's unlikely. Then if they find no significant impacts, they issue their FONSI, boop, we're done. They found that there were significant impacts, then we have to move into that third category of the environmental impact statements, right, which has those series of steps: issuing their notice of intent, doing a draft, allowing for public comment, issuing their record of decision, and then it moves forward with granting the permit or authorizing the action. So again, that's kind of a quick, really quick run through of the NEPA process, right? When would it get triggered? Once it's triggered, what options or paths can the agency go through to make its decision of whether to grant or deny an application, issue a permit or not? The one thing I want to restate before that I'd mentioned, if we go back to the slide way over, so NEPA applies to a major federal, get back there. A major federal action. Oh, yeah. Include in every recommendation or report on proposals for legislation. So Congress, if they're proposing a bill, some legislation, they do not have to go through a NEPA analysis. It's only if the agency, like a federal agency, was kind of proposing something, then they have to include this analysis. So Congress, the Congress is that way in so many things, right? They can kind of do what they want, which is why it's very important who you vote for, because they have a lot of power and authority, particularly over issues involving tribes and tribal communities. So in the last little time here, I want to talk then about, all right, how do I comment? Heather, how do I get involved? I'm not working for an agency. I have no plans to go and work for an agency to do kind of NEPA analysis and reviews. I just want to be able to voice the community concerns, my concerns when some action is being proposed near my home. How do I do that? And on this slide, right, you see that the biggest opportunity for public comment is once the agency has put out their report. Okay, and so real quick, how do you comment? These are written. So a agency, at the very beginning, they do a notice of intent where they'll identify the project. That kind of triggers to let people know that something has been submitted or something for their consideration, and you can kind of follow it along. Different agencies have different levels of transparency online. Okay, the BLM, the Bureau of Land Management, the agency that is most involved with, say, like oil and gas development, energy development, particularly on lands near reservations. They have a really good online NEPA portal where you can search for decisions. You can see all of their different documents that they put up. They're probably one of the best, right? Each of the other agencies will vary, though, in what's available online. Although all of this, the whole point of NEPA is to be transparent. So all of it should be available. And sometimes, right, with our tribes, they come out, they have to, there's consultation requirements too, that also can put you on notice. But anyway, the first thing is, right, being kind of aware what's happening. And then if you decide it is something important, something that you want to comment on, you submit written comments to the agency that's overseeing the work. And, you really want to, in your comment, identify with specificity what issues they need to be considering. If you're aware of any studies, any scientific public health studies that are relevant to show the impact on the environment, the impact on human health, right? Put those in. And you want to look at the purpose and the need that has been identified and comment on whether there were any alternative ways of achieving that purpose, fulfilling that need that the agency should consider, perhaps didn't, right? In containing a clear ask, right? And part of that goes to the things above, telling the agency, you need to consider these specific studies. You didn't identify this risk or this harm that might occur. You didn't consider this alternative that would achieve the same outcome, things like that. Comments that are supported by research, credible evidence are going to carry a lot of weight and make it difficult for the agency to ignore. Okay, so again, right, scoping, that first initial notice of intent that the agency releases, they will get comments. You can comment on those based on the proposed action and the need. And then the next big point is comments after that draft EIS is issued before the final EIS is carried out. And something that's really important about NEPA commenting is that in order to legally challenge, file a lawsuit, right, for the tribe in the DAPL cases, those tribes, for them to file that lawsuit and make a NEPA claim, they had to show that they commented during the NEPA process to be able to follow up with a lawsuit later. So if you don't comment and then the agency does something that you think was wrong and messed up, then you will lose that ability to contest it later on. Okay, helpful comments, couple tips here, right? Inflammatory or accusatory, that's not the place to do that. Leave that to your kind of Twitter and social media. It isn't really helpful. And sometimes, honestly, in the legal world, the court, if they read that comment, it might lower, kind of their evaluation of it when you throw in things that just aren't really necessary in our name calling. Opinions that are unsupported, right? That this is a really, really interesting one. So I think most people are familiar with Violence Against Women Act, the Missing and Murdered Indigenous Women. Studies have connected man camps that are set up from oil and gas development near reservations. They've connected that development, the establishment of man camps, with an increase in violence against women. Okay. If you just state your opinion in a comment to oil and gas expansion, bringing in all these non-native workers is going to increase violence against our community. If you just state that, it's easy to it comes off as your opinion, easy for the agency to kind of disregard. Now, if you state that and then you include the citations to the studies, that's a different matter. Now they have to look at those studies. They can't as easily dismiss it. And in fact, that is what happened in an EIS that was near the Wind River Reservation, a project that went out there just a couple years ago. So again, to the extent, try to always support it with some citation, a study, so that it's not just your opinion. Again, kind of polarizing strong language, avoid it. It's not the place for it, and be specific. So overall, last 2 seconds here, right? I don't know. Have I convinced you it's a good law? I don't know, right? I love NEPA because it's a procedural requirement. And it's one that if the agencies don't comply with, their decision gets kicked back. So there is that opportunity for public to bring attention. There's an opportunity to raise treaty and trust responsibility rights, right? Certainly makes jobs for people like myself. And it also brings attention to things when there's like Clean Water Act, Clean Air Act, other considerations. But it's an expensive process and it's a long process. It takes a lot of time for the agencies to go through this. One kind of account was in that 2012 statistics that on average EISs took 4.6 years to complete. So the applicants, the people who want to do the development, the proponents of the action, that's a long time to wait for the government to make a decision on your proposal. And again, this is the takeaway. It's a procedural. It does, at the end of the day, after the agency goes through everything, it doesn't mandate a certain outcome. doesn't mandate that the environment and health be protected above all else, above resource development. But at least it's something, and it's a tool that environmentalists, EJ activists, that we have and that we absolutely should be wielding. So there was a good question here about, people have been following McGirt in Oklahoma, right? So the U.S. Supreme Court found that the reservation boundary, Muskogee Creek Nation, was still intact. And then since then, we've had, I'm sure, right, all our Oklahomans here. Since then, we've had all of our the tribes in Oklahoma, similar things, Cherokee Nation, and all the others. And then it's a really unique situation, what's happening in Oklahoma, because then the states went to EPA and asked that they have jurisdiction over kind of environmental decision making. It's hard for me to answer that in like 2 seconds. I'll just say it's unique what happened because of other laws, and so what's happening in Oklahoma is a little different. The interior, just with their environmental regulation. Yeah. And I haven't followed what the tribe, like whether Biden is going to kind of review that decision, because there were some arguments that when the state of Oklahoma requested that authority, that the EPA didn't necessarily have to grant it. And so I think it'll be interesting to see what happens over the next few months. And again, obviously with our new interior, Deb Haaland, right? A lot of people are very optimistic that tribal issues will be brought to the forefront. Some people were disappointed that Biden did not shut down the DAPL permit right away, that he's still allowing it to go through the review. But I think it's a long way from being over. Sorry, I wish I could. I don't feel like I answered your question very well, but this is part of the challenge of, right, 574 tribal nations, and Alaska is very different than the continental kind of U.S. tribal situation as well. But my kind of takeaway is with NEPA, if you don't raise your concern, you're making it that much easier for the agency and the proponent to just go ahead and do what they want. But when you exercise your right to comment, when you support it by the science, that, again, like climate change, right? Trump administration was really ignoring a lot of the science that had been established behind climate change. And that we're seeing that shift now back, like the climate change is back on the federal agency web pages. But when you include that, even though the Trump administration the agency wasn't considering climate change, the courts were, because those studies had been raised in comments, and the court is a separate, again, government branch. And so I feel like the NEPA process, that procedure allows individuals to put forth their rights and their concerns, notwithstanding the political kind of changes that can happen between administrations. Because again, the courts will be looking at, did the agency consider everything that they should have? And if they didn't, it's going to be remanded and they're going to go through it. And what's happening here, new presidents on board. So, we'll see what happens with DAPL. But I'm optimistic that, the claims were asserted, and that the tribal rights and interests will be protected. So again, lots of let me put so again, it's heather.tanana@law.utah.edu. I'll put it up there. So it's a very, very quick one. If tons of resources out there. If this is an interest of yours, please reach out to me. There's a lot more that you can share. And I'm happy to chat anytime. Okay.
Great. Wado, thank you, Heather, for your presentation and a lot of these important points and resources and connection. I certainly was enlightened in a lot of ways. I thought, NEPA was Environmental Protection Act. So thank you for that clarification of not to get those confused and mixed up. We also want to remind people we still have time for questions. So thank you, Heather, to already starting to address those. But we do want to remind people that we are sharing a link to an evaluation form for this session. And for the NSU Symposium, we always gather feedback, which is great for improving the symposium following this one. And we share that feedback often with the presenters like Heather, and it's been helpful for me in previous years. And we're getting to our 50th soon, so we're excited for symposia ahead and appreciate your feedback on that. But I'm glad that someone did bring up that question about the McGirt case. Heather, just in a nutshell, though, would you say it just opens up, a can of worms, or is it just because I wasn't really sure about, is NEPA different in Oklahoma now because of the, figuring out and navigating what the implications are of the McGirt case? Are there any cases right now? I know you have colleagues in Oklahoma who I'm sure this is on there. And you've heard a lot of the conversations about the implications of the McGirt case. Sorry to push you on that a little more, but
yeah, I mean, it's a little complicated because right, like the land status hasn't changed in Oklahoma. And what I mean by that is that if an individual owns land in fee, tribal member or not, it's still their land. And so that hasn't changed. What we have the exteriors of the boundary, though, being recognized, and what that will trigger is for certain environmental laws, right? We look to the exterior of the boundaries and tribes being able to have a say in environmental regulation within that region. So NEPA, again, is going to be connected to federal lands. So for the most part, a lot of times it's like granting an oil and gas development for someone on federal lands. And in that area, right, Biden did a little kind of put a halt to new oil and gas leases. So any project that's already on the works and you're going probably is not going to change, right? And again, like a tribe, if they want to develop their own resources, which they absolutely can, they don't have to go through a NEPA process unless they need an ease. Where it gets really tricky because sometimes, right, we have checkerboard reservations, and so you might need an easement across a non-tribal owned land to be able to get the line across, and then maybe if that's federal and not tribal, NEPA, that's where NEPA would be triggered.
Awesome. Yeah. Awesome. Well, we are unfortunately back to back in our sessions, so we have to get ready for our next session. But thank you so much, Heather, and thank you for sharing your contact for the questions we could not get to. I encourage people to definitely follow up with Heather. I think something that I've really taken away from this conversation is what we can do, and what it means to comment, thinking about who are the decision makers, the people and the processes and mechanics of, all these structures that we navigate and the laws. So it's exciting and much appreciated to learn about that and to think about what ways can people be trained to comment, our tribal nations and indigenous communities doing that. So those are some thoughts that were sparked for me. And I'm hopeful with some of the developments with that, knowing how much environmental justice and our environment and the connections of indigenous peoples with our homelands is and are. So thank you, Heather. Sorry we have to wrap up so soon, so much to talk about, but thank you again for joining us.
Thank you, everyone.